CIV PRO 4, Pretrial and Motions. Let's start with pretrial remedies. First, we have our temporary restraining order, or TRO, which we know may be without notice or ex parte. So how long does a TRO last? That's right, it lasts 14 days. Can it be extended? Yes. Another 14 days for what? Good cause. And this converts it to that's right, preliminary injunction, and sets date to adjudicate it upon notice to the defendant. All right. Can you appeal a TRO? Absolutely not. And what is our legal standard? 1, immediate and irreparable harm. 2, likelihood of success on the merits. Okay, what's prong 1? That's right, immediate and irreparable harm. What's prong 2? That's right, likelihood of success on the merits. Okay, why can a TRO be given without notice? Well, many reasons, but the attorney has to certify in writing why notice should not be given, or they can also certify that they have attempted to notify the adverse party. So why should notice not be given? Who has to certify to that? That's right, the attorney. Or attempts to notify? That's right, the attorney. All right, TRO, 14 days, no appeal. Can it be extended 14 days for what? That's right, good cause. Converts it to what? That's right, a preliminary injunction. And our 2-prong standard is 1, that's right, immediate and irreparable harm, and 2, that's right, likelihood of success on the merits. Next up, preliminary injunction. The preliminary injunction, do we have to have notice? Yes, we do, whether we move for that immediately or it's an extension of a TRO. Therefore, is it appealable? Yes, a preliminary injunction is appealable, a TRO is not. All right, there are 2 + 2 factors for a preliminary injunction. The first 2 are familiar from our TRO. Irreparable harm if the injunction does not issue. 2, likelihood of success on the merits. 1, irreparable harm if injunction does not issue. 2, likelihood of success on the merits. Okay, what about 3 and 4? 4 is the balance of equities favor the moving party and or injunction is in the public's interest. Irreparable harm likely if the injunction doesn't issue, likelihood of success on the marriage, and 1 of 2. Either the balance of equities favors the moving party or the injunction is in the public's interest. Okay, 2 + 2. Irreparable harm likely if injunction doesn't issue. 2, likelihood of success on the merits. And either, that's right, balance of equities favors the moving party, or, that's right, the injunction is in the public's interest. Okay, moving on to pretrial motions and judgments. A motion for a more definite statement. What's our legal standard? That's right, the complaint is so vague or ambiguous that the defendant cannot reasonably prepare a response. When do you have to move for a more definite statement? Well, obviously before you respond to the complaint. If you think it's that vague or ambiguous and you file a responsive pleading, well, I'm sorry for you. Okay, the complaint is so vague or ambiguous that the defendant can't reasonably prepare a response. When do you have to file it? Before filing a responsive pleading. So you move for a more definite statement. What does the plaintiff have to do? Well, they can amend, right? How long do they get? 14 days. 14 days leave to amend to make the motion after a motion for a more definite statement. Moving on, motion to strike. What do we move to strike other than evidence that the judge admitted over our objection? immaterial, redundant, impertinent, or scandalous material. And we can move to strike 21 days after service. What a surprise. You got served. You get 21 days to respond. Okay, motion to strike. What's our legal standard? Immaterial, redundant, impertinent, or scandalous material. So we've got our motion for a more definite statement. Complaint is so vague or ambiguous that the defendant cannot reasonably prepare a response. We've got to file that before we respond. Motion to strike, we're going to file that 21 days after service. And we do it for immaterial, redundant, impertinent, or scandalous material. Okay, the wonderful 12B motions to dismiss. We've got our raise it or waive it motions. We've got our anytime motions. And we've got our before or during trial motions. And we know this. Lack of PJ. That's right, you've got to raise it or it's forever waived. Don't raise it in your pre-answer motion or in the answer. Consider it waived. Lack of SMJ. When can we raise that? That's right, any time. Improper venue. That's right, raise it or waive it. Insufficient process. Raise it or waive it. Insufficient service of process. Raise it or waive it. Okay, how about our last two? Failure to state a claim upon which relief can be granted. What does that really mean? That you failed to plead facts sufficient for a plausible claim, or that there's no relief possible under the law. So that's our 12B6, failure to state a claim on which relief can be granted. We fail to plead facts that may give us a plausible claim, or no relief possible under the law. So that is a claim that can be raised during trial, before or during trial. And then there's failure to join an indispensable party. Okay, we know what an indispensable party is. That's a party that it's a necessary party. They are indispensable because the litigation cannot proceed without them, such that the court should likely dismiss the lawsuit. Okay, so we've got lack of PJ, raise it or waive it. Lack of SMJ, 12B2, anytime. Improper venue, 12B3, raise it or waive it. Insufficient process, 12B4, raise it or waive it. 12B5, insufficient service of process. That's right, raise it or waive it. Failure to state a claim upon which relief can be granted, 12B6. Before or during trial, we fail to plead facts for a plausible claim, or, that's right, there's no relief possible under the law. And 12B7, failure to join an indispensable party under Rule 19. Next up, motion for judgment on the pleadings. We know this one. Say it. That's right, after the pleadings are closed, but not so early as to delay trial, a party may move for judgment on the pleadings. Question, can you attach evidence like affidavits and transcripts of deposition? No. We're moving for judgment on the pleadings, just the pleadings. After the pleadings are closed, not so early as to delay trial. Okay, there are 3 things we must plead with particularity. 3 things we must plead with particularity. 1, mistake. 2, fraud. 3, special damages. MFS, mistake, fraud, special damages. MFS, mistake, fraud, special damages. We must plead them with particularity. And what's our acronym? Acronym? MFS, mistake, fraud, special damages. We plead them with particularity, or what? Well, we probably will get a motion to dismiss for failure to state a claim. If we don't plead the fraud with particularity, special damages with particularity, mistake with particularity, we are failing to state a claim under Rule 12b-6. So we probably are going to get a motion to dismiss for that. Okay, so let's talk about responding to a pleading. Of course, when are we going to file our pleadings, our responsive pleadings? Oh, yes. We got served, 21 days. We waived service, 60 days. Or 14 days after the court denied your Rule 12 motion. Your pretrial motion, you get 14 days after the court denies your pretrial motion to file your responsive pleading. So you file your pretrial motion, the court says, heck no. 2 weeks later, you must file your responsive pleading. Okay, so it's really 21 days after service, 60 waiver, or 14 days after the court denies your Rule 12 motion. Do you have to plead all your affirmative defenses in your first responsive pleading? Yes. Plead the affirmative defenses or waive them. Plead your 12b defenses. Plead lack of PJ. Plead improper venue. Plead improper process. Plead improper service of process. Otherwise, they are, yes, waived. Waived. Plead those affirmative defenses in the responsive pleading. Okay. Line by line, we're going to admit, deny, or say we don't know. You can make a general denial, but if you fail to deny, you admit on any issue except what? Damages. That's right. Why? Because damages are for the jury to decide. You fail to deny, you admit on any issue except damages. Damages are for the jury to decide. What if you say you don't know? Well, that's a denial. Okay, moving on. Motion for summary judgment. We can move for summary judgment up to 30 days after the close of discovery. Okay, so unlike a judgment on the pleadings, a motion for summary judgment happens after discovery. Motion for judgment on the pleadings, we're just asking to judge based on the pleadings. We haven't done discovery yet. So our summary judgment standard is 30 days after discovery. We can move for summary judgment. What's our legal standard? Oh, yes, no genuine dispute of material fact, and the movement is entitled to judgment as a matter of law. And the evidence is viewed in the light most favorable to whom? The non-moving party. And of course, we have gone through discovery. So do you think you can support a motion for summary judgment with evidence? Yes. Affidavits, depositions, admissions, answers to interrogatories, even performance reviews. You can move for summary judgment when? Up to 30 days after the close of discovery. And what's our legal standard? 1, no genuine dispute of material fact, and the movement is entitled to judgment as a matter of law, and the evidence is viewed in light most favorable to the non-moving party. Can you move for partial summary judgment? Yes, you can. Yes, you can. All right, speaking of judgment as a matter of law, which used to be called a directed verdict, what's our legal standard? No reasonable jury would have a sufficient evidentiary basis to find for the opposing side. No reasonable jury would have a sufficient evidentiary basis to find for the opposite side. Let's not send this case to the jury, judge. No reasonable jury would have a sufficient evidentiary basis to find for the opposite side. And the judge will say in response, well, yes, but all facts will be construed in the light most favorable to the non-moving party. All right, legal standard, no reasonable jury, sufficient evidentiary basis to find for the opposite side, and all facts are construed in light most favorable to the non-moving party. When can you move for JMOL? After each side's rest or after both sides have rested? But always before what? Before the case goes to the jury room. Okay, you moved for JMOL. Good for you. You preserved that because the jury comes back without a favorable verdict. you get to move for JNOV or renewed JMOL. You have to have moved for it before, but after the jury comes back with an unfavorable verdict, you can move for JNOV or JMOL 28 days after the verdict. Renewed JMOL 28 days after the verdict. And if it's granted, what happens? Well, the judge may overturn the verdict, right? Okay, talking about a motion for relief from the judgment or to set aside the judgment. How long do we have to file that? A year, 1 year. Why so long? Well, it may take us a while to discover the following things: mistake, surprise, excusable neglect, fraud, misconduct, or the big one, newly discovered evidence that could not have been discovered with due diligence. Or the judgment is void, it's satisfied, or it has been vacated. Okay. Motion for relief from judgment, how long do we get? That's right, we get a year. And what are our grounds? Mistake, surprise, excusable neglect, fraud or misconduct, and newly discovered evidence that could not have been discovered with due diligence. Okay, let's break that down. Ground 1, mistake. Ground 2, surprise. Ground 3, excusable neglect. Ground 4, fraud or misconduct. Ground 6, newly discovered evidence that could not have been discovered with due diligence, or the judgment is void, has been satisfied, or vacated. And how long do we get to move for relief from a judgment? 1 year. All right, how about a new trial? What's our legal standard? 1, the verdict is against the manifest weight of the evidence, or 2, newly discovered material evidence that could not have been discovered by due diligence. Of course, you must show that you were diligent in searching for that evidence before trial. Okay, motion for new trial. Standard 1, verdict is against the manifest weight of the evidence, or 2, newly discovered material evidence that could not have been discovered by due diligence. Do you have to show diligence in searching for it before trial? Yes. How long do you get to move for a new trial? 30 days. Interestingly, renewed JMOL or JNOV and a motion for a new trial are often pleaded in the alternative. For RJMOL, you get how many days? 28 days after the verdict. For a new trial, you get how many days? 30 days. I don't know why, just memorize it. All right. So, can the court move for a new trial on its own? Yes, the court can order a new trial on its own for a judge's error, misconduct. So a party, a witness, an attorney, or juror misconduct, that could result in an order for a new trial. A mistake by a judge, we definitely are going to get a new trial if the judge recognizes a mistake. Or excessive verdict that shocks the conscience for remitter. Remember, there's no additor in federal court, and the court may offer remitter of the judgment in lieu of a new trial. When do we never get a new trial? Harmless error. No new trial if we have harmless error that did not affect the outcome of the case. Okay. Motion for relief from the judgment. How long? That's right, 1 year. How long for motion for a new trial? That's right, 30 days. How about for JNOV? 28 days after the verdict. What's the legal standard for motion for a new trial? That's right, verdict against the manifest weight of the evidence, or, that's right, newly discovered evidence that could not have been discovered by due diligence. How about relief from a judgment, or to set aside a judgment? Ground 1, that's right, mistake. Ground 2, that's right, surprise. Ground 3, that's right, excusable neglect. Ground 4, fraud or misconduct. Ground 5, newly discovered evidence that could not have been discovered with due diligence, or the judgment is void, satisfied, or vacated. All right. When is the last moment to move for JMOL? Before the case goes to the jury room. Okay, when do we never get a new trial? Harmless error that did not affect the outcome. All right, amending pleadings. We get an amendment. That's right, once as a matter of right within 21 days of service of the last pleading. Once as a matter of right within 21 days of, that's right, service of the last pleading. Or, that's right, by leave of court. And leave to amend shall be freely given when justice so requires. Can you amend pleadings? Yes, once as a matter of right within 21 days after service of the last pleading, otherwise by leave of court. Leave to amend shall be freely given when justice so requires. How about supplemental pleadings? When do we want to supplement a pleading? Well, we might want to add a claim. What do we need? Permission of the court. And again, leave to amend shall be freely given when justice so requires. Okay, let's talk about the doctrine of relation back. Relation back allows someone to file an amendment and have it essentially relate back to the original date of filing. It redates your amendment as if it was filed before the statute of limitations has run. Okay, remember, how long do we get to amend a pleading as a matter of right? 21 days. It's 22 days. Oh, we need to amend our pleading. The SOL has run. What does the amended pleading need to do? Relate back to the original pleading. To add a new claim from the same what? Conduct, transaction, or occurrence as the original pleading. Look, this guy hit my car. I pleaded negligence, but I didn't plead. Then he hit me after I got out of the car. I didn't plead assault or battery. Does that claim arise from the same conduct, transaction, or occurrence as the original pleading? Yes. We are going to file it. Hopefully the court will allow us to amend it. It relates back to the original pleading because it arises from the same conduct, transaction, or occurrence as the original pleading. In my little example, the same car accident followed by an assault. So that's adding a new claim. We want to amend our pleading under the relation back doctrine. We're amending it late, 22 days, shit. To add a new claim, it has to arise from the same conduct, transaction, or occurrence. But what about we want to add a new party? Let's mix up our scenario. We got into a car accident. The driver came out and gave us his license, but the passenger got out and hit us in the face. Uh-oh, now we need to add a new party. So now, the legal standard is actually, this is a terrible example. The other party knew, but for a mistake in identity, they should have been the one sued. To add a new party, they knew, but for a mistake in identity, they should have been the one sued. Okay, so let's make this scenario, ridiculous as it is, more realistic. We're in a car accident with twins. One twin is driving, the other is not. They both get out. One twin hits us. Tim hits us. Thomas gives us his license and is very nice. We sued Thomas for the battery, but we should have sued Tim. Does Tim know he hit us? Yes, he knew that, but for a mistake in identity, he should have been sued. All right, enough with the ridiculous examples. So relation back redates an amended pleading as if it were filed within the 21-day amendment period. It relates back to the original pleading to add a new claim that arises from the same conduct, transaction, or occurrence as the original pleading, or to add a new party if that other party knew that but for a mistaken identity, they should have been the one sued. Okay, side note, the other party has to know of the suit and they have to be notified within 90 days. All right, that's it for pretrial and motions, all the way up to relation back. Next up, joinder.